On February 1st, as many people know, Regan Benson got word about Denver police going down to West Tennessee Avenue. They were there to enforce signs that were posted illegally.
That they were out here on a bullhorn.
Need a gift for your man this holiday? Meet the $60 Japanese knife the internet is calling a samurai.
Yep.
They were here illegally on the street to enforce a sign placed by Denver Parks and Recreation. So
Park like that.
Regan was out here yelling at them, which eventually resulted in them leaving the scene. 17 days later, a warrant was issued for her for interference as a result of this. The signs, though, that the police were enforcing were placed illegally, and they failed to do what they were supposed to do. And let me explain what that means here in a moment. Let's go on to this one on February 12th. The police were out here with Denver Parks and Recreation handing out tickets. And the tickets that they were handing out by the Parks and Recreation state that they were overnight parking. This is in broad daylight, mind you. As you can see, it was in the afternoon of February 12th, where Park Ranger here, with the help of the police, were handing out these tickets. The people were forced to identify by the police, who then handed the information off to the Rangers, who then wrote the tickets. The police are doing this to avoid losing their qualified immunity, because they know that these signs on the park here are illegal. And, well, they should have known that they were illegal. How is that? So therefore, it should have not have happened this way, that any tickets were handed out. This is a public street, of course, on Tennessee Avenue. And the Rangers, the park rangers, have no authority out on the public street. But the police aren't handing out the tickets so that they don't get themselves into a lawsuit and lose qualified immunity, because I think they know that it isn't. And we're going to fast forward to March 20th, where Regan encountered the park ranger again, having Denver police force a person to identify, and then giving him a ticket in an area that is not a park. If you look up on the map where this location is, this particular location is not a park at all. Warren Avenue, I think it's Warren Avenue, is right there on the left, right up here. And you look on the map for this pullout section, this section here is not part of the park. And the ticket states on it that they maintain it. And park rangers are given many things to do, which is some of those duties, of course, are taking care of the parks and rec facilities. But they're often tasked to clean up areas that are marked as open space and areas like that, because they have nobody else that covers that. So they automatically give it to them saying, this is open space. We want you to keep it clean and maintain it. So this is translated into by the park rangers as they have full control over it, when in fact they do not. The Denver Revised Municipal Code gives them specific powers, which I go over here in a bit. And they harass this guy and give him a ticket for the, they say, illegal dumping, which, since it isn't park facility area, well, it's in a sense, it is an area, but it is not part of the park. They're still handing out tickets. And of course, if this was a crime, the police would handle it, but the police are not handling it because they want to avoid losing their qualified immunity over all of this. So we're going to go over a little bit about the signs, a little bit more, and then we're going to go over it again with different parts of it. But the city traffic engineer is given duties in the Denver Revised Municipal Code, and when their office was established, the records that they keep, the records that they keep of streets and everything. So this is what they're supposed to be doing. So getting records from them has been proven more than difficult. I've put in two or three requests now for that specific street and have not received a single piece of paper from the city traffic engineer indicating what the parking restrictions, limitations, regulations, or prohibitions are on that street. I did get it in writing in an email stating that there is no restrictions, limitations, regulations, or prohibitions on that street, but that doesn't show it in the public record as they're supposed to maintain in the office. But their powers relating to what they do is listed in here. They're planning and design of streets, and their powers are, they shall have the power and authority hereby empowered and authorized upon the basis of traffic engineering or other investigations and studies, or necessitated by a particular character of the roadway, highway, or streets, or any other public way, to determine speed limits, parking, and everything else. So, by way of example, but not way of limitation, shall have the power and authority upon the basis of traffic engineering investigations and studies too. And he gives you a whole list of things, like they can establish one-way streets. And number 6 here, establish parking restrictions, limitations, regulations, and prohibitions. That is their duty. And it is not the duty of Parks and Recreation to establish that on a public right-of-way. It is actually the city traffic engineer, their job to do that. So they have to do all kinds of things. And another thing that they must do, let's go to this one. They control encumbrances, 49246. Let's go to 49246. 49. See if I'm in the right section. Not quite yet. 246. Getting closer. Street. Oh, this is the next one down. I just saw it. Encumbrance is in the right of way. All right. Order of removal for section 49-246 under the Denver Revised Municipal Code. The manager of transportation and infrastructure, or the manager's designee, which would basically be the city traffic engineer, who would be the designee for this, is authorized to remove or to order the removal of any article, vehicle, or thing whatsoever encumbering any street, alley, sidewalk, parkway, or the public way or place. Any such thing hereafter this article is called an encumbrance. An encumbrance can be any number of things. It can be a newspaper stand, one of the ones that you can walk up to and put coins in and pull out a newspaper from. It can be a kiosk. It can be any number of things. And they have to have permission to put it into the right of way. Also is what is considered an encumbrance is also a sign. So under 49-247, if the manager orders the removal of an encumbrance which has not previously been permitted, such as the signs of that Denver Parks and Rec had put up, and is not legally in the right of way, which that falls under, said encumbrance shall be immediately removed by the owner, or the manager may immediately remove such encumbrance. Now, this is where they're failing, because Denver Parks and Rec and the police have convinced the Department of Transportation and Infrastructure that they want these in place, even though there hasn't been any process for putting them up legally. Now, here's the part where the police failed. It shall be the duty of all members of the police department to report to the manager such encumbrances and to remove the same in accordance with the provisions hereof. So the police, it was their duty to report it to the manager, and there has been no report to the manager as of February 1st. Instead of reporting it, they chose to enforce the illegal signs. They did not remove them, or at least they tried enforcing them. They did enforce on February 12th, but they didn't enforce it through the police department, even though it was their duty to report this to the manager that this was happening and to remove these encumbrances of these signs that were posted illegally. They chose to help the Parks and Rec by identifying people that were on location, providing the Parks and Rec with their identifications so that they could write administrative tickets, where fighting them is extremely difficult because it's stacked against them. So the police department has failed in this section. So let's go to, let's see here, 54-483. 54-483. Let's see here. See where we're at. Well, way past it. 483, we're close. 458, we're close. We need 483. Here we go. 483. Parking in accordance with posted signs. The signs have to be placed by the city in accordance of specific guidelines. There has to be a study made. It has to be approved by DOTI, the Department of Transportation and Infrastructure. And of course, it must be on file with the city traffic engineer. So at any place within the city where authorized signs are posted pursuant to the provisions of this chapter giving notice of parking limitations, blah, blah, blah. It shall be unlawful for any person to park in a manner in violation to or contrary to the provisions contained on such sign. So it has to be under specific things. At any place within the city where authorized signs are posted pursuant to the provisions, which those weren't posted pursuant to the provisions of this chapter, giving notice, blah, blah, blah. Let's see here. It shall be lawful person to stand, stop or stand. It tells you basically if the sign's put up, you have to obey it, but it has to be put up in the correct way through the city traffic engineer. And the city traffic engineer shall cause a record to be kept of all the streets, other places where that happens at. And this is where the city has failed me multiple times, because it says the traffic engineer shall furnish a copy thereof to the police department, the county court, and those public agencies or members of the city council requesting the same. That's one of the things of it, though. Shall be open to the public inspection during business hours. I requested the business hours and days open, and they will not give those to me. So I can't go there in person to inspect these records in person. And that's the part that they're failing again. So, but existing signs to be enforced, posted with appropriate signs giving notice at the time of passage of this code into law. This is when this is wrote. This doesn't mean prior, and I believe this was 1950 that this was put in there. Shall be effective parking. So they're not talking about just because it's up there and it exists that it has to be followed because it wasn't put up legally. It has to have been up before 1950. So let's see here. Unless otherwise changed by the city traffic engineer, and unless otherwise authorized, shall be unlawful for any person to park, stand, so on and so forth. So they failed with this there, and we're going to go into there. By the way, this is a screenshot. Let's do it this way. This is a screenshot of how the records were kept before. I used to be able to click on them, and it would give me the full property information by clicking on it, by who owns it, the schedule number, and everything else. Now you can't do that. I'll go into that here in the recording coming up. This is one of them that they failed. It said, I'd like to record of all work orders for the address of 501. And they responded to this one that there is no record of work orders. And therefore they didn't exist. Therefore there was nothing to enforce. But they have had four signs out here in the front of it, placed illegally by Parks and Rec on private property, which is not even controlled by them. This is a screenshot of the area right in here where people can pull off, where the one guy was given a ticket based on the fact that Parks and Rec maintains the area, but it's not part of the park. I gotta do it this way. This is a picture of the signs that they'd put up, and of course it says 39-4 for no overnight parking, and when I go over that here shortly too, and they failed to do that. This is the signs that they put in place of the other ones, and they don't look like city signs. It's because they're not. The Parks and Rec made these signs and put them up to make them look like city signs, so that they didn't have their logo on it and didn't have their code on there. So by making it look like the city put these signs up, they were in effect trying to trick people into thinking that the city traffic engineer had these put up. And there's no stickers on the backs of them, of course. And I did check the record, and DOTI admits that the Parks and Recreation put those signs up as well. And I go in for this. I had this in here because of my own ticket, and it shows the property lines and, of course, who owns it and the schedule number and everything. And goes to show you where the property lines are of a specific park. You can no longer look on the map and get the specific property lines. So if you had clicked on the left side of it, it gave you the property information there. And if you look at the map here, you can see this side over here on the right side of the blue line is the public sidewalk. And what happens when you click on that public sidewalk, that's just a farther view. This is what happens when you click on the sidewalk part of that. No parcels found at this location. So without a parcel being there, it means that sidewalk is not part of the park. There's a closer view of that same thing. No parcels found at this location. So this is an area where they're tasked to clean up, but do not fully control. But they're like, well, we got to clean it up, so therefore we control it, but that's not how it works. So let's go here to media, open file, test, open. And we want to,
For this segment, I'm going to talk about
video
corruption with Denver
playback
Parks and Rec.
speed.
And we are going to start with,
And we're going to play this in quick speed so it doesn't bore you guys too much.
this is a section that is the DRMC, Denver Revised Municipal Code, that gives them the authority that they have. It's very strict in their limitation on what they have authority over. Under section 2.4.4, control all facilities relating to parks. So of the city charter, the manager of the Department of Parks and Recreation, the manager has the power and authority to adopt rules and regulations for the management, operation, and control of parks, parkways, mountain parks, and other recreational facilities, and for the use and occupancy, management, control, operation, care, repairing, and maintenance of all structures and facilities thereon. So it has to be on their property of a park, a parkway, mountain park, or other recreational facility that is marked on the map. And all land on which the same are located and operated has to be on there, on which the same are located and operated. So Article 1 of Chapter 39 of the Revised Municipal Code set forth, in accordance with the City Charter, the authority to enforce the rules and regulations adopted by the manager by way of example, blah, blah, blah. Such rules and regulations may provide the following, and it goes over what they can do for that. So we're going to go over here to 39-4. To be unlawful for any person other than an authorized personnel to engage in any use of or activities in area or part of any park, parkway, mountain park, or other recreational facility in violation of any temporary directive issued by the manager restricting or prohibiting such use or activities. And in order to enact that, you have to look at section 39-2, adoption of rules. Under normal procedure, any proposed rules and amendments to the rules shall be referred to the Board of Parks and Recreation by the manager. The Board of Parks and Recreation shall consider proposed rules or amendments to the rules and make recommendations to the manager within 45 days of the board's receipt of the proposed rules or amendments to the rules. So the manager shall cause to be published a notice of proposed rule making at least 20 days before conducting public hearings on the proposed rules or amendments to the rules. The notice shall include the following information: the date, time, place, and subject of the public rulemaking hearing, requirements, if any, for interested parties to notify the manager of their intent to participate in the hearing, including the manner of such notice and the deadline for such notice, and a statement that the complete text of the proposed rules or amendments is on file with and may be examined at the office of the manager and online at a specified website. So the manager may make changes in the text of the proposed rule or proposed amendment prior to, during, or as a result of the hearing. So any person who wishes to comment on a proposed rule may do so in writing, delivered to the manager prior to the date of the hearing, or in person at the hearing, subject to any requirements for participation set out in the notice of hearing. If minutes are not prepared, the manager shall preserve proceedings at the hearing on audio magnetic tape. Okay, let's go back to the 80s. Or similar audio recording media so that the proceedings may be transcribed at a later date at the expense of the one requesting the transcript of the hearing. Not so much for, public documents. They're making it available, public record. The rules shall become effective upon dating and signing of the rules by the manager and the approval of the rules for legality by the city attorney. So it has to be approved by the city attorney. Within 7 business days after adoption of the rules, the manager shall file a copy of the rules as finally adopted with the clerk and recorder and the city attorney, and shall cause to be published a notice of their adoption in an official publication of the city. The notice shall include a statement that the rules are on file with the manager online at a specified Denver website and available for public inspection and copying. Any judicial or quasi-judicial action to contest the validity of the procedure in adopting the park rules may not commence more than 120 days after the adoption of the rule. This is the important one right here. The manager may adopt a temporary directive without following the notice and hearing requirements of the section if such action is necessary to comply with state, local, or federal law and is deemed necessary by the manager to protect immediately public health, safety, or welfare, or to protect or preserve a park, parkway, medium, or mountain park, or other recreational facility. After adoption of a temporary directive, the complete text of the temporary directive so adopted shall be filed with the city clerk, and a notice of adoption shall be published as the same as above, where they are required to publish it. The temporary directive adopted in such a case shall take effect on the date of adoption or at a later date specified in the temporary directive. However, such temporary directive shall not continue in effect for more than 180 days after the date of its adoption or after the later date specified in the temporary directive. So it can't take effect unless those steps are followed for it. And we already know they haven't filed anything with the city clerk, and they have not run anything through the city attorney. Now let's go over to here. Denver Parks and Recreation Policies and Procedures, effective 11/18/2016, Parks Designation Policy. This is something that they wrote on their own and put out. So they're trying to rationalize what they do and what is a park and what is not a park. But we already know what a park is because it's marked on the city maps, on the plat maps, Tax Assessor maps, of what the locations are of all the parks in the city. Now they are given duties other than taking care of the parks, and this is where they're blurring the line. So they're saying, understanding how the Denver City Charter, city ordinances, and other applicable laws classify and protect Denver parks is not always a simple matter. This policy is adopted by the Denver Department of Parks and Recreation. This is a policy that they have. You will not find this in the Denver Revised Municipal Code. For the purpose of providing some clarity as to the designation, status, and the protections afforded to Denver parks under existing legal framework, and to set forth a public process with respect to designation of Denver parks in accordance with city charter and city procedures. So this is formatted in a question and answer format to assist in comprehension. So what is a park? Appearances of a park is typically recognized by certain common characteristics such as playgrounds, playing fields, basketball, tennis courts, golf courses, public swimming pools, picnic tables and shelters, pavilions, public restrooms, or other amenities intended to promote public recreation and outdoor activities. Often a park includes characteristics that may be shared by other publicly owned property that are not parks, such as open space, landscaping, natural areas, sidewalks, trails, and paths, plazas, water features, and the like. Appearances can frequently inform one as to what is a park, but not always. Legal classification. Under Denver historic practices and legal framework existing, a park can be identified. What follows is a listing of the key legal classifications. A park which has been or will be designated as a park in accordance with Section 2.4.5 of the City Charter. A designated park can also be a Denver Parks or dedicated park. Once classification as a dedicated park, classification cannot be changed without a vote of the Denver electorate. See Section 3 below. It goes over what a dedicated park is, and then it also has an unclassified park. Any park developed, operated, and maintained by DPR that is not classified as a designated park or dedicated park. However, not all land developed, operated, and maintained by DPR is a park. And that's where they blur the lines, because they are set by the city to maintain areas that are not parks, because trails and other things are not. But they are enforcing their rules on areas that are not parks. So what is not a park? While DPR is often involved in the development, maintenance, and or public use regulation of landscaping, trails, sidewalks, open space, natural areas, and other features located on city-owned property, not all that property is a park. The most common examples of this non-park property are listed below. This is the important one here for the purposes of putting up signs and trying to control the public right-of-way. Parkways and boulevards listed in Section 49-16 of the Denver Revised Municipal Code, and all rights-of-way dedicated by ordinance for street or alley use, such as Tennessee Avenue. That is a right-of-way dedicated by ordinance for street or alley uses. And let's go back over here to 4916. 4916, let's find that. 4916, designation. The following are designated as parkways and boulevards, and they have control of these particular places. or they don't have. Let's see what it said again. It said, oh, that they're not. All right, so all of these listed here are not parkways, or listed as not a park. So parkways and boulevards listed in section 4916 are not a park. And there is a lot of areas, including West 14th Avenue Parkway between Bannock Street and Broadway, right next to Civic Center Park. That is not a park, as they state, or as stated by them, that it is not a park. All of these parkways and boulevards are not parks. They're on this list. So let's go over to Denver maps. Now this part here is the interesting part, because earlier this month, a person was able to go in and click on an assessor map for the city of Denver. It was an interactive map, and they were able to click and find properties and who owns them just by clicking on them. I believe because of my research, you can no longer do this. This is Tennessee Avenue here, and you can see that there is a mark over here, red line, that's a property line for 501 West Tennessee Avenue. It used to be able to just click on it, and it would tell you who owned the property and give you all the details of it. They no longer want me to know, or anybody to know, that this is private property right here on this mark. We get rid of that and move that over there, so that you can see here that all of this is marked Vanderbilt Park. So they want you to believe, because this is green, that they control it, when in fact it is private property that belonged to Gates Rubber Company at one point, that was across the ways to the east. And now it belongs to BSP West LLC. I haven't checked the zoning maps to see if they changed, but you can no longer go anywhere on this map and look up a property of who owns it. There is no more interaction anywhere. So if you want to look up, you can see the lines of the properties still, but you can't look up the property. This is what you get now when you click on it. You zoom in a little bit here, give you an example here. 002 is Civic Center Park. There's one problem here. You can't click on it, get its designation to get the number to look it up anymore. You can't click on anything on this map to get the number that you need to look anything up. They're forcing people to now go through a request. And this only started within the last 3 weeks. Since the last time I was on was March 4th, looking up the properties. It has changed. And previous to this, for years, you used to be able to interact with the maps. A lot like Adams County here. This is Adams County's map, and I'm zoomed in on Commerce City at the moment. You click on something, and it tells you who owns it. This is the city of Commerce City, Attention Director of Finance, and this is the address. This is what the other map used to have. You had the parcel number, who owned it, and the address. So you'd be able to click on something and see exactly who owns it. And you can go to a property report at this point and look up taxes and everything. This is a tax assessor map, just like the other one. And you can just click on things and say, oh, this is the city of Commerce City owns this. This is the parcel number. And you can go to a property report. And this is at 6000 Victory Way. You click on the property report. And this is what a property report shows for 6000 Victory Way. Account summary, the mill levy. It's a pretty high mill levy. But you'll find it's a city property. So there's no sales records found. Valuation. They assess this as $44,920 with an actual value of $154,907. And the tax summary. And you can do the search for the tax summary. Click here. And it's not going to let me go in. I was able to look this up before. Let's go back. I was able to look up how much taxes were paid on this before, because it lists somewhere here. Let me see if I can find it. Zoning. Oh, that's Commerce City. It used to have on here how much or who was responsible for the taxes. And now it wants me to log in, and it didn't have that before. So they've hidden this in Adams County as well. So let's see what that one says. Oh, this one says log in as well. So we can't look at that one. We can only look at this. So I had figured out previously how little taxes were paid on this because it's leased out. But they have changed theirs as well, so people can't figure it out anymore of who's paying taxes on what as compared to this. Go to a property report of this one. Go to tax summary. No, it's not telling me a tax summary on this one either. Count summary gives me information of the lot, the tax district. Let's see what I get on the tax district. It's just giving me the tax district report for it, so it doesn't give me any specific information. Go back to there. All right, we have a sales price, but we don't have this, the trustees webpage. Let me see here. This is what you get from Adams County now. Registers use a logon and password. And well, we can maybe do it. Parcel number. Well, let's go. What's the parcel number from this one? From the other one that it wouldn't tell me. Copy. Parcel number. Paste. Search. All right. One item found. Balance 0. All right. Basically, it's saying for that, actual and assessed and taxes are still 0, even though it's leased out property. So they have changed their site, so I can't look it up anymore. No surprise there. So go back to Denver's. Denver's is even worse now because it's now in a block area where you can't look up the individual parcels who owns it on anybody. This could be a business. These are businesses down here, for instance. I can't look up any of these businesses. Who owns this property? Who's paying taxes on it? How much taxes is being paid on it? So they have now gone completely from interactive maps that gave you all the information to basically having to request it from them and pay them for it in comparison. So we shall see what happens with that.
Okay, that was played through real quick for you, so you weren't bored. And this is continuing with the police trying to avoid lawsuits by losing their qualified immunity by using Parks and Rec to enforce rules to remove homeless people and harass them. So until that's stopped, which it probably won't, there's nothing we can do. And the city is covering up what's going on for it. All records requests. It took multiple times for requests before they finally admitted that Parks and Rec put up these signs, but they have not removed them. In fact, they've gone forward with helping Parks and Rec to make this zone a no overnight parking zone instead. So they're enabling the police to then enforce those signs, and they don't have to go through the park rangers. They very much know what they're doing on this for the police, that they're trying to avoid lawsuits and losing their own money because they know that these signs are illegal. But once the city approves those signs, then they'll start writing their own tickets instead of going through the park rangers. And it's 100% legal at that point, and they won't lose their qualified immunity over for that. But in the meantime, this is the dirty tactics that they're using. And this is as much as I can report at this time until more records come in. So we shall end with let me see here. We're not going to end it with that. Never mind. We shall just end it for here. Thank you guys for watching.